Hello, welcome to the Literary and Jury Charge for the 60 class. Today we're going to start out with a narrative answer. I'm going to read this at 60. Ready? I was driving down the highway on my way to work. I travel that road every day. There was nothing unusual about the day in question, except, unfortunately, it was the day the defendant hit my car. I would say I was going approximately 65. I know everyone always says that, but it's the truth. I was going the speed limit. I rarely speed. Maybe if I'm late, I might go 67 or 68. Ask anyone who knows me. They'll tell you too. My best friends make fun of me and tell me that I drive like an old woman. I have never even gotten a ticket in my life. I try to do the right thing, but he hit me, and now my car is totaled. Okay, I have some jury charge for you. Okay, ready? You're going to hear the word police officer, which is P-L-I-F-R, if you want to use the brief for that. And you're going to hear the word misdemeanor, which I write that M-I-F-D. So that's up to you if you would like to write that down, M-I-F-D for misdemeanor. Defendant, D-E-F-T. Your Honor, Y-U-R-N. Okay, here we go. Couple of points. Basically, it appears that we're alleging the arrest was illegal. The first person to mention sex was the police officer. The first person to mention a specific amount was the police officer. The solicitation, if one occurred, would appear to be done by the police officer. In addition, very briefly, the items we're attempting to suppress on independent grounds, even if the arrest was legal, were contained in the desk area, some distance away from the room where my client was arrested. No search warrant, no consent. It cannot be termed to coincide with the arrest. It certainly was not within arm's reach. my client, as a matter of fact, was never seen at that desk at all prior to her arrest. She was in the custody of the police officer, either handcuffed or not, still under his control. At the time, she was inside the room, then apparently let out and down the hallway and ultimately out of the building. So the items that were seized cannot be justified under any of the theories that are permissible, and it certainly cannot be incident to an arrest, since the arrest was some distance away and well beyond the necessary area that the courts have deemed improper. Your Honor, I submit to the court that the arrest was legal. It's a misdemeanor committed in the officer's presence. He has a reasonable belief that that misdemeanor has been committed in his presence. The argument that Mr. Van Hoy is trying to use is that it was illegal because the officer, I presume it's kind of like an entrapment argument, but that would not really be the issue in the 1538. That would be a trial issue. The issue really is whether or not the officer at that time had a reasonable belief that a crime had been committed in his presence, which I submit to the court that he did, subject to that arrest. He seized certain items. Those items were in plain sight. They had been items that he had seen before. They related to the defendant's participation in the crime on the premises, identified by her as being part of the premises, and were and related then to the crime itself. I think he would have a reasonable belief that those items do relate to the crime that he arrested Miss Colbert for. Under those circumstances, it would be a reasonable seizure. The issue is not addressed, I don't think, as far as the medication that was found in her purse on booking. I submit, first of all, the arrest is legal. Therefore, the booking, the finding of the search is legal. The medication, finding the medication is legal. And the question really then is, because if there is any significance, whether the officers threw any medication away, I submit to the court an item was found but has no value or sense. It has been destroyed in terms of hitch, and it has no probative value for the defendant in terms of guilt or innocence. Other than that item would have no significance from either to her guilt or a good faith destruction of that evidence should not result in its suppression. Based upon that, I submit the matter. I don't believe the plain sight doctrine applies. We don't have items of contraband here. These are not items that are susceptible to being seized upon the sight of a police officer. They very well may be in evidence. I will concede that point, but that simply isn't enough. The law doesn't state that you can seize evidence anytime that you want to, even if it's in plain sight, if it's not contraband. I would submit there is no consent by the officer's testimony. The arrest is a great distance away. It can't be testified as an incident to the arrest. There's no warrant. It's the people's burden to come up with a justification for the seizure, and merely to state it's in plain sight and it is evidence is not sufficient. For it to be in plain sight, it has to be contraband. And these items certainly are not. It is. The officer could have come back at a later time with a search warrant. He could have arrested Miss Colbert at any future date that he wanted to. They could have torn the whole place apart, perhaps looking for records and other items. He chose not to do so. So to go ahead at that time, the law says that is simply impermissible, and those items should be suppressed. I'm restating the earlier grounds as to hitch on the medication. Okay. My next selection for you is going to be an article, and this is called 6 Worst Health Mistakes Women Make. And if we don't get through all of it, we'll finish it off in the next class. Okay, here we go. I will read this at 60. Ready? Carol Parrish of Roswell, Georgia, was a preschool teacher with a husband, 2 children, numerous volunteer activities, and not much spare time. I hate to admit this, she said, but I hadn't been to the doctor for a routine physical since my 6-year-old was born. I just didn't get around to it. Sound familiar? Probably. According to experts, women's biggest health mistakes have to do with not paying enough attention to themselves. It's not always easy to shift the focus from work and family to oneself, but the likely payoff, a longer, healthier life, is worth the trouble. Underestimating heart disease. Surveys have shown that about 40% of women consider breast cancer their leading cause of death. But that distinction belongs to cardiovascular disease, which kills more than 500,000 women a year, more than all cancers combined. Also, some doctors are slow to recognize heart disease in women. A study at the University of Illinois School of Medicine found that only 38% of women were referred for further testing following an abnormal stress test, compared with 62% of men. Women were diagnosed and treated for heart disease only half as often as men in the first 3 years after the onset of symptoms. Okay, I'm going to stop there because we have concluded our class. I will finish this article in our next literary and jury charge class. Okay, have a great day.